This conference will now be recorded.
Okay, good morning, everybody. Welcome to our second class of the day. Today, we're going to be talking about seller documents. The first thing we're going to look at is the listing agreement. And this is meant to be interactive, so feel free to jump in and ask questions at any time. If you're online, I'm not able to monitor the chat, so just unmute yourself and speak up and ask your question, okay? So let's go ahead and jump right in. The first thing that I want you to notice is the title. This is the Residential Real Estate Listing Agreement, Exclusive Right to Sell. And that means that this agent on this agreement is the only person who is legally authorized by the seller to offer the home for sale. I got this question from an agent a week or two ago. Can 2 or 3 brokers list the property? And the answer is no. Certainly not on this agreement, because this is an exclusive right to sale, okay? All right, paragraph 1 deals with the parties. The parties to this agreement are the seller and their address. And by the way, that's not necessarily the property address. The seller could live elsewhere. This could be a second home. It could be an investment property. And what you're putting under paragraph 1 is where the seller lives. And if it's in the subject property, it will be the same address, but not necessarily. And then secondly, the broker. This is not where you put my name and home address. Who is your broker? EXP, specifically Tony King, but what you're going to put here is EXP Realty and their official address. And that could be an Austin address, a Dallas address, it could be a Houston address. Once we get this office certified as a branch office, it could be this office address, okay? As long as it's an official EXP office address. Seller appoints broker as seller's sole and exclusive real estate agent and grants to broker the exclusive right to sell the property. So you're not going to see a C21 and a RE/MAX sign in the same yard. In other states, by the way, they do allow that, called an open listing, but it's not available under this agreement, certainly in Texas. The property. This is very similar, by the way, to the offer, the 1 to 4 family. You identify the parties and then you identify the property. Property means, very important, land, improvements, and accessories. Those are the 3 things that are being sold. We typically think when somebody purchases a home, they're purchasing a home, and we think of the physical structure, but it's actually composed of 3 components. The land, we know what that is. Improvements, what's an improvement? Anything built upon the land. So that would include the home. If it's a detached garage, the garage, a shed. Would a pool in the ground be an improvement? Absolutely. So we're buying the land and all these things that have been built on it. And then it also says we're buying accessories. And if you think some of these are going to show up on the test tomorrow, you are exactly right. Okay, look at this. Let's go through. It's worth it. So first of all, the land. We have to identify that. We do it first by a legal description. Lot, block, and addition. In the city of, in the county of, and then says known as, that's where you put the address. You don't need to put, again, the city and the state, right? So you just put the street address, 123 Elm, and then the zip code, because we've already told them what city it's in, and we've acknowledged that it's in Texas because this is a Texas exclusive sale document, okay? All right, B, improvements, the house, garage, any fixtures and improvements attached to the above. So anything attached to the house, attached to the garage, attached to the swimming pool, including without limitation the following permanently installed and built-in items, if any: equipment, appliances, valances, screens, shutters, awnings, wall-to-wall carpeting, mirrors, water softeners, kitchen equipment, garage door openers, shrubbery, landscaping, outdoor cooking equipment, et cetera, et cetera. Okay? Any questions about that? Okay, so are water softeners included in the sale of a home? Have you ever shown up on a final walk and the water softener's gone? Not yet. Well, it happens. Trust me, it happens. It says here, permanently installed items. What about a refrigerator? Ever? Okay, so this is tricky. If it's a typical refrigerator that you roll in on wheels and you push back in the little alcove there, that's personal property. It's not part of the improvements. However, if it is permanently installed, in other words, it doesn't have that exterior casing because it's designed to fit in, have custom woodwork all around it, then that would be permanently installed. It's not designed to be pulled out and taken to the next house. But I have seen issues where a family might take a roll-in refrigerator and then case it in with beautiful trim that would have to be removed to get the refrigerator out. Now, is that real property or personal property? That's what judges decide, okay, when it becomes a lawsuit. So you want to avoid that. Bob?
Would it be best then to put it on a non-realty item addendum, just to be safe? It's to be.
So yeah, yes. So if the seller is going to take it with them, even though it's kind of trimmed in, they'll want to put it on the exclusion list. If the buyer absolutely wants it and they want to be assured that it's included in the sale, then they could use the non-realty and identify it there. That probably would be the most appropriate. I hesitated because we're calling it non-realty, but it could be realty. But as long as it's clearly identified by brand and serial number and model number, then a court is always going to say, what was the intent of the parties? Was the intent of the parties clear? And as long as it's clear, then it will be enforceable. Okay? Accessories. This is often a point of contention. The following described related accessories, if any: window, air conditioning units, stoves, fireplace screens. Think about that. Fireplace screens. You would think that's personal property. I mean, you bought it at Lowe's, came home and set it down in front of the fireplace. It is presumed to be part of the home. Real property. It's identified right there. Curtains, rods, blinds, window shades, draperies, rods, door keys. They are included in the sale of the home. Mailbox keys, above ground pool, swimming pool equipment, the little skimmer that you walk around to get the leaves out. You think that's personal property because, again, you bought it at the swimming pool supply store. No, it is considered an accessory and stays with the home. Controls for garage doors, entry gates, other improvements and accessories. Controls include sellers' transferable rights to the software and applications used to access and control improvements and accessories. Okay, a little Nest thermostat, you know, that's a lot of people want to take those with them and put up the old-fashioned analog type. But if they do that, they better either exclude it or, smart best practice, take it down first and put the old one up there. Yes, Will? Yeah, so generator would definitely be considered an improvement because it's attached and affixed to the real property, okay? Unless it's my generator, which is on wheels. And if you got about 3 strong guys, you can pick it up and move it, okay? But I mean, seriously, it weighs about 500 pounds, but it's on wheels and you can move it around. So that's personal property, but you, yeah. Yeah, so in my opinion, that's personal property. I'm going to do the same thing at my house so I can run the whole house from the generator, but it's still a portable and I still just plug it in to the electric box, okay? But if there's doubt, we should put it in the contract, either in the exclusions or in a non-realty. Okay? And where do we put exclusions? Right there, D. The following improvements and accessories will be retained by seller and must be removed prior to the delivery of possession. If there's a whole bunch of stuff, there is a separate addendum to the contract, the seller's exclusion list, where you can list all 15 items. Okay, if you need to go into more detail, but if you can fit it in here, do it right here. How easy is that? There's a seller's exclusion addendum. I don't know that it's a promulgated form, but I know at Abbey Realty we provided it. And most brokerages will have one. I don't know if EXP does. Anybody gotten that far yet?
If we're going to use the extra form, the inclusion form, on line D, would you say see attached to the?
I would. Yep. Yes. Yeah, you would. Yeah, put in paragraph D, the attached exclusion addendum. Yeah, I sure would. And then I would reference it in the 1-to-4 contract where it lists all the other documents that are part of it. Okay. Yeah, so cameras are attached, and so they are presumed to be part of the home. Yep. All right, owners association. The property is or is not subject to mandatory membership in a property owners association. This is the seller informing who? The listing broker, right? This is an agreement between the listing broker and the seller, but now the listing broker has the information to properly present the home in the MLS. Listing price, seller instructs broker to market the property at the following price, and you put that in there. By the way, I love the language, seller instructs broker. Why would it use language like that? Yeah, well, that's what an agent does, right? And so,
the listing agent.
yes, so an agent is one who acts at the request of another, on behalf of another. So the seller is instructing us, market the home at this price. There's a phrase I use, you're going to hear it 10,000 times if you come to my classes, and it's reflected in this language. We, as real estate agents, are the consultants. Our clients are the decision makers. And we need to maintain those boundaries in our own minds, because quite often we take on the decision maker hat. Like, well, why didn't my sellers accept that offer? They're not going to get a better one. And we lose sleep over this kind of stuff, and we stress over this kind of stuff when we never need to. It's not our issue. We're not the ones to decide. As a consultant, we explain to our clients the various options available to them and the likely consequences of each choice. In the example I used, Mr. and Mrs. Seller, we were asking $365. We have an offer for $380 on the table, cash, close in 14 days. Now, we've been marketing for 2 weeks. This is the best offer we've gotten. And from what I've seen, inventory is expanding in this neighborhood, which means buyers are going to have more options. My best guess is that this is going to be the best offer we get. And based upon your personal needs to be in Pittsburgh in 2 weeks, I would recommend that you consider it strongly. Okay? But it's on them. We gave them our best professional advice. What they do, and let's say it sabotages their plans and costs them thousands of dollars, and they end up accepting an offer for $340 3 months from now, we can sleep well. We gave them our best advice, we did our job, but we never want to step over into their shoes and take ownership for their decisions. That's what will keep us up at night, because we can't do anything about that. Okay? The term, the listing begins on blank and ends at 11:59 p.m. on blank. If seller enters into a binding written contract to sell the property before the date this listing begins, and the contract is binding on the date the listing begins, the listing will not commence and will be void. Okay? We put, and this is a real risk in today's market. We may put a listing date in here of a week out because we want to give them time to get it cleaned up. We got to get a photographer in there, that kind of stuff. A neighbor could hear it's about to go on the market and come over and buy it. That happens all the time right now because there's so much pent up demand. If that happens, then we're not going to get paid if it goes under contract before the listing period begins. Now, what if the listing begins on Wednesday and Thursday, a neighbor comes and knocks on the seller's door and say, hey, I want my kids to move into the neighborhood. I'll give you full price cash right now. Are we getting paid on that? Why? Because we have an exclusive right to sell, right? Nobody can cut us out of the deal at that point. So you're right, we will get paid, okay? When earned and payable, seller will pay broker blank % of the sales price. Let's see, what does the listing broker make? Typically, sometimes 3. So what do we put in this blank? That's right. And this is confusing to sellers. You need to be prepared to explain it. That what we're saying here is that the fee earned by the listing brokerage is 6% or 5.5% or 8%, whatever it is. Now, we're going to see a little bit later in the listing agreement that we're going to cooperate with the other 34,000 real estate agents in Houston to sell your home. And as the listing broker, we're going to offer compensation to them for their assistance. But that compensation to them is going to come from us, not from you. You're going to pay us, we're going to pay them. So as long as you keep that understanding in order, the listing broker pays the buyer's broker. The seller just pays the listing broker. That's why the total commission shows up right there. That box number 2 in paragraph 5 is a blank. You could write in there a fixed fee. And you'll typically see this not in a listing agreement for a home, but in an unimproved property listing. If you're listing a lot for $8,000, do you want to be paid 3% on that sale? Somebody do the math. What is it, about $240? Not a good day's payday. So on lower priced properties, often lots, you won't see a percentage, you'll see a fixed fee. $2,000, $1,500, whatever's appropriate, and typically a percentage is not going to adequately compensate you. Okay? Yes, ma'am.
But number 4 on the terms, is it typically 6 months at this point?
So is the listing period typically 6 months? 6 months, I would say, is the normal market standard. In this market, I wouldn't put 6 months. I would go shorter period. I would probably do 3 or 4 months because I know I'm going to sell it in 3 or 4 days. So putting 6 months in there almost makes it look like I don't know how to do my job. I don't know, but it's completely negotiable between listing broker and seller. But in this market, I don't think I would put 6 months. Letty?
So the listing date, is that going to coincide with when you put it on the MLS, or the listing date could be physical or signed and then put it on MLS?
So you want the listing date to coincide with your public marketing going on the MLS. Now the MLS does allow you a grace period. I think it's 5 days. Is that correct? So once you go active, you have to have it on the MLS within 5 days. But I don't know why you would wait. If you're trying to sell the thing and you're active, get it on the MLS ASAP. Okay. Okay, Dave. We're in 5B, earned. Broker's comp is earned when any of the following occurs during this listing. And by the way, I happen to know a test question comes from this paragraph. So seller sells, exchanges, options, agrees to sell, agrees to exchange, or agrees to option the property to anyone at any price on any terms. Woohoo! That's pretty universal, isn't it? Broker, individually or in cooperation with another broker, procures a buyer ready, willing, and able to buy the property at the listing price or at any other price acceptable to seller. Now think about that. If the seller lists the home at $285, you bring them an offer at $285. Let's just say it's a cash offer. 21-day close, and they say no, are you entitled to a commission? Yes, you are. You have earned that commission. You brought them a ready, willing, able buyer who was willing to purchase under the terms that they offered. Now, they're not required to sell the home. Don't misunderstand me here. They haven't signed a sale contract. So they're under no obligation to that buyer who made the offer. But they are under obligation to you as the listing broker to pay your commission. Isn't that simple? How do we know that? That's what it says. Okay? And the contract rules. The contract rules, that's what it is. So, or seller breaches the listing. How could they breach the listing? We're going to see a whole bunch of seller obligations we go through this, as there are listing broker obligations. And if they don't keep theirs, let's just say, for example, they don't make the home available for showings. They've breached the agreement. You're entitled to a commission. Well, you might have to sue to get it, but the contract rules and a court would rule in your favor. Okay. All right, payable. Once earned, broker's comp is payable either during the listing or after it ends at the earlier of closing and funding. Seller's refusal to sell after the broker's comp has been earned. Seller's breach of this listing or at such time as otherwise set forth. Okay. Broker's comp is not payable if a sale of the property does not close or fund as a result of seller's failure without fault of seller to deliver a buyer to the buyer a deed or a title policy as required by the contract to sell. Okay, very important point, because this came up recently on a transaction I was involved with, or one of our agents was involved with. Was say there's a cloud on the title. Seller was unaware of it. Or, no, this is a real life one. This was one of my deals. Got a contract to sell one of my listings. It was an heirship situation. There were 16 heirs scattered all over the world. Some of them we couldn't even find. They were in Australia, unresponsive to any communication. And some of the ones that we found wouldn't cooperate. They did not like the two sisters living in the house and didn't want them to get, because it was a mixed marriage kind of thing, and they didn't want them profiting from their daddy's house. So we literally were unable to close, but it wasn't the seller's fault. They were unable to deliver clear title, and so therefore they didn't owe a commission. Okay, loss of ownership due to foreclosure or other legal proceeding, or seller's failure to restore the property as a result of a casualty loss to its previous condition by the closing date. So you're under contract to close in 30 days, the home burns down, the seller can't get it rebuilt in 30 days. So they're released from the obligation to pay your commission, okay? Are they released from the obligation to restore the property and sell the home? Well, that's another issue outside the scope of this contract. This is just an agreement between the broker and the seller, okay? Other comp, I'm not going to take time to go through all that. You are welcome to read it, but look at D2. This is important. Yeah, go ahead. Yes. That's correct. The seller is supposed to act in good faith to deliver clear title, and that would include clearing any clouds on title that they could. Say there was a mechanics lien against the property for $1,500. They're expected to pay it off or pay it out of the proceeds of the sale. The title company can arrange that. But there are certain clouds on title that simply cannot be fixed by the closing date. And if that's the case, then the seller is released from their obligation to pay the broker. Okay? All right. Now, by the way, just in the sale contract itself, if the seller fails to deliver the general warranty deed, which means all these clouds have been cleared, then they're in default of the contract by the closing date. If they can't clear them, they're in default. So they don't have to pay us a commission, but what obligations do they have to the buyer? Or what options does the buyer have? So those options are outlined where in the sale contract? in paragraph 15 of the 1-to-4 family contract, it outlines the remedies of the non-defaulting party. And what it says in that case, yes, the buyer could retain the earnest money as liquidated damages, or the buyer could sue the seller to enforce performance, saying, well, doggone it, you missed the closing date, but you still got to clear that title and you still got to sell me the home. So those are the options available to the buyer. All righty. Look at subparagraph 2, service providers. If broker refers seller or a prospective buyer to a service provider, for example, a mover, cable company, that's a long word, telecommunications provider, utility, or contractor, broker may receive a fee for the referral. It's good news, isn't it? But you notice the companies it lists, none of them are settlement providers under RESPA. It doesn't say mortgage, title, or insurance. That would be illegal. But when NRG comes in here and says, you get a buyer and a contract, let us set up all their utilities, let us pitch them on our alarm company, and we're going to pay you $250, is that legal? That's what it says right there. It's legal. You can be paid. Home warranty companies. So, by the way, you may recall under Abbey Realty, we stopped accepting referral fees from home warranty companies because both I and our counsel, Michael Hughes, came to the conclusion that that was a violation of RESPA. And I didn't want to run that liability. But EXP came to a different conclusion. And different companies do. Everybody comes to their own conclusion. And they have an arrangement where you can be compensated by making a referral to their preferred home warranty company. Okay, so on our team, we're going to do that. We're going to get paid that little extra money. And by the way, I don't even think I've put this in our team agreement, but that won't be subject to the team comp split. It's probably going to be reversed, where it's going to be 75% in favor of the team member with just the 25 or the token amount to the team. Okay. But EXP is on the hook for the liability, so here we go. Another benefit, that's right. So protection period, this is important, very, very important. Protection period means that the time starting the day after this listing ends and continuing for however many days, 10 days, 30 days, 60 days. Sell means any further transfer or any fee simple interest in the property, whether by oral or written agreement or option, okay? So what this is saying is there's a certain circumstance under which you as the listing broker can be paid even after the listing expires or is terminated. That's interesting, isn't it? Well, what are those circumstances? Not later than 10 days after this listing ends, broker may send seller written notice specifying the names of person whose attention was called to the property during this listing. And that would really be anybody who saw the property, anybody that you showed, anybody that any other broker showed the property. Do you have access to that list? Yeah, sure. The showing service keeps a record of it. Okay, so you just provide that list within 10 days of the end of the listing period to the seller. If seller agrees to sell the property during the protection period to a person named in the notice, or to a relative of person named in the notice, seller will pay broker upon closing the sale the amount broker would have been entitled to receive if the listing were still in effect, okay? So they can't terminate the listing and then make a side deal with one of those people who saw it to cut you out of the deal. Would a seller ever try that? I'm about to sue somebody right now for doing that. Have another conversation with the attorney today. It was $1 million lot and a $2.5 million custom home. We're talking about $100,000 in commission. Our agent introduced the client to the landowner to the builder, got them all together while it was listed with an offer of compensation. Then they terminated the listing and the seller and the buyer got together and made the deal and hired that builder to build the property. We are going to sue them, okay? Because we have the right to be paid. Now, very important, 3, this paragraph 5E survives termination of the listing, but very important, this paragraph will not apply if seller agrees to sell the property during the protection period, the property is exclusively listed with another broker who's a member of Texas Realtors, then the seller, and the seller's obligated to pay that broker, there's no protection. Did you hear that? All the seller has to do to invalidate any protection you have is to list it with another broker. So if they list with another broker, that broker is going to be paid a commission, even though you introduced the buyer to the property or they were introduced to the property by another broker during the listing period, you will not get paid if the seller relists. So it's only really protection if they don't relist, they're trying to avoid paying a broker and do a private sale. Yes.
If they're not a member of Texas Realtors,
Then this wouldn't apply.
then it wouldn't apply.
Yeah.
Even if they relisted with a broker, if that broker wasn't a Texas Realtor.
That's correct. Then they would be on the hook for how many commissions? 2, because they would absolutely owe the new listing broker a commission, plus they would owe you a commission, okay? By the way, it's the same exact situation with a buyer rep agreement. There's a protection period on that. You're working with a buyer, you show them a bunch of houses, they say, you know what, I think we're just gonna do our own thing. The next thing you know, they buy the property that you showed them and cut you out of the deal. Because the seller told them, if I don't have to pay a real estate agent, I can give you a lower price, okay? If you had provided their names within the protection period, you're gonna get paid unless they did what? Hired another agent to represent them. And if they did that, it invalidates any protection you had, okay? All right, F, you just specify the county where they're to be paid, and just specify the county of your office, which would be the EXP office that you list in paragraph 1. Okay, if that's Austin, then put Travis County. You know, if it's this office, then you're going to put, we're actually north of the creek, so we're in Montgomery County. Okay. All right, listing services, paragraph 6. This just puts the seller on notice that you are going to be listing with a listing service. Let's read this. If the property is publicly marketed, MLS rules require that broker file this listing with an MLS within 1 business day. Everybody see that? I take back what I said about 5 days. We all missed that one, didn't we? 1 day, there it is. Public marketing includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing, public-facing websites, brokerage website displays, including IDX and VOW. That's what I wanted to get to. IDX, Internet Data Exchange. You've heard me say this over and over, but I want you to see it's in the contract. What that means is that we, as the listing broker, can put their home out on a website that is subject to IDX, Internet Data Exchange. That means every other broker in the MLS has the right to market this property. That's why you get to choose any active listing, regardless of who the listing broker is, and market those properties on your website and with core property booths, or any other way that you want to market that property, okay? IDX gives us the right to promote each other's properties, okay? Filing, it goes through, if the seller wants to delay going to the MLS a few days, they can specify that. Or not go on the MLS, they can specify that. Why would they ever want to do that? Yeah, so a lot of sellers have privacy concerns and they don't want the general public seeing the inside of their home. and they will say, you know, the listing broker can market the property within their sphere, within their contacts to other brokers, but they don't want it out in the general public. Happens all the time on super high-end properties or with celebrity sellers. You know, everybody wants to go see, you know, Deshaun Watson's house, that kind of stuff, you know. No, he's not going to allow that. All right. Again, the various options for the MLS for either delaying or not putting it on there. Access to the property, paragraph 7. Remember what I told you we would get to some seller obligations and broker obligations. Here's a few right here. Authorizing access to the property means giving permission to another person to enter the property, disclosing to the other person any security codes necessary to enter the property, and lending a key to the other person to enter the property directly or through a key box. To facilitate the showing and sale of the property, seller instructs the broker to, and then it just goes through, access the property at reasonable times, authorize other people to access the property, duplicate keys to facilitate convenient and efficient showing. So they give you one key, but you're putting 2 key boxes. Now you have written authorization to go make a copy. Scheduling companies, here's where you list who you're going to use to as your third party. Is everybody using Showing Smart? Pretty slick. No, Showing Time is what we used to use. Oh yeah, you got to get yourself some listings. Come on now, come on. Showing Smart is the Showing Time alternative, the alternative to Zillow owned Showing Time that was developed by HAR. And it's super simple. And I've got an active buyer. I've been showing a lot of properties the last few weeks, and Showing Smart is so super simple. You can actually schedule right from the property description on the MLS. You pull it up, Showing Smart, yes. I've not had a glitch. I've listed a home on it, and I've worked with a lot of showings, scheduling showings, and I find it really easy to use.
Do you have to get back to your seller for Showing Smart? I haven't seen how to do that.
I don't know. You just log into HAR, and they'll have a link to it right there. It is an HAR product developed specifically so we're not giving our money to Zillow. Okay, and it's free. That would have saved me $6,000 a month. You realize that? Why couldn't they have developed that last year or year before? Because I paid for your showing time, and that was averaged about $6,000 a month. You're welcome. Okay, key box, authorized or not authorized. In best practice, I just recommend that you put a super on the front door or as close to it as you can, and a mechanical on the back gate as a backup, because sometimes the super doesn't work, or sometimes you'll have somebody come in from out of town who doesn't have super access. It'll be an Austin agent, a San Antonio agent. They don't have, even though they may have a super in their market, it doesn't work in our market. And you don't want to have to run out to the property and let them in. So you put a mechanical combo on the back gate, or if it's an appraiser, they may not have super access, or a plumber or an electrician. And so it'll just save you countless trips and hours if you have a combo on the back gate for those kind of situations. Okay, so you always need 2 keys and have 2 types of lock boxes. Okay. So the supers are probably about $135 now. Yeah, they're pretty expensive. The combos you can pick up at Home Depot for $20. Order them online, $20, $25. Yeah. Liability and indemnification. It just says that you're going to be held harmless if somebody showing the property harms themselves or, you know, steals the lipstick or whatever. They can't sue you for that. Cooperation with other brokers. This is where we offer to pay a cooperating broker. MLS subscribers. If the other broker is a participant in the MLS in which this listing is filed, broker will offer to pay the other broker what? If they represent the buyer, let's say 3. If they're a sub-agent, 0. Abbey Realty would not pay sub-agents. EXP will not pay sub-agents. A sub-agent is who? Someone who brings you a buyer but does not represent the buyer. So by default, whom do they represent? The seller as a sub-agent of the listing broker. And listing brokers get very nervous about that because they don't know that agent. They don't know their practices. They don't know what promises or lies they've told. So it's a common practice for brokers to refuse to pay sub-agents. If you want to bring us a buyer, then represent the buyer. Have a contractual representation agreement with them. Non-MLS brokers. Do we pay an agent from Lubbock who brings us a buyer? Of course we would. They brought us a buyer, come on. And they're representing their buyer. It's in the state of Texas. It's all legal. So here you put, what are we going to pay them? Now, here's where this pops up sometimes. Galveston. Does Galveston have their own MLS? They participate in HAR, but I think they have their own as well. They may put in their listing agreements, if you're not a member of the Galveston MLS, we're only going to pay you 1%. Why would they do that? Because these Houston agents call them all the time and say, hey, I'm sending a buyer down this Saturday to see your property. Would you mind letting them in? And they get tired of that. And so they'll say, we're only going to pay you people from outside our area a reduced commission. That's why that's in there. Okay? Yeah. All right, intermediary. Intermediary status. I love intermediary. Maybe questions about this on the exam tomorrow. Intermediary can only be authorized by what? By the client. And how? In writing. Intermediary can only be authorized in writing. If it's a seller, where does that writing, where is it found? Right there, paragraph 9, okay? Intermediary status. Broker may show the property to interested prospective buyers who broker represent. That means any agent under the same brokerage. And since EXP is one brokerage in the state of Texas, if they say no intermediary, no EXP agent can show that property. Okay, one brokerage. So, but it'll say it's okay. If a prospective buyer who broker represents offers to buy the property, seller authorizes broker to act as an intermediary, and broker will notify seller that broker will service the parties in accordance with one of the following alternatives. So this is if they check this box, this authorizes EXP agents to show the property and to make offers on the property, but it says right here that if one of them makes an offer, the broker is going to take another step. What is it? You're now going to notify that seller. You said we could do intermediary. Guess what? We're in that situation. It's happening. We have to tell them. And we have to further tell them what type of intermediary it is. In other words, is it level 1 where I'm the only agent, I'm the listing agent, but I also brought the buyer? If that's the case, my responsibilities to you have been dramatically reduced. Or we have to inform them this is going to be a level 2 intermediary. We're under the same broker, but the broker has appointed another agent to represent the buyer, and here's that buyer agent name, and therefore they and I will be able to offer our respective clients full service. All the original duties that I promised to you, including confidentiality and loyalty. I still have to be honest with all parties. Doesn't give me the right to lie to the other party, but now I'm in your corner and I can give you advice and I can advocate for you. Does it make sense? Okay, level 1, level 2. Or they can say, no intermediary status. I don't want your broker involved on both sides of the deal. Okay. Bum, 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 bum. Paragraph 10, confidential. Oh, this is interesting. This is a little known fact in our industry. During this listing or after it ends, broker may not knowingly disclose information obtained in confidence from seller except as authorized by the seller or required by law. Broker may not disclose to seller any confidential information regarding any other person broker represents or previously represented as required by law. Actually, that's not the paragraph I thought. That's just very obvious. We're going to get to it. It's going to show up. Here's the issue that I was thinking was going to be covered in this section. If you're the listing agent in a multiple offer situation, are you permitted to share details of the offers you've received with the other agents? Like I said, little known fact. Wait for it. And I've been in this situation myself. On Sunday night, I presented an offer on behalf of my buyer. It was listed at $350. We offered $365 cash, 21-day close. She says, you're not even in the ballpark. I said, well, help me out. What's the seller looking for? What do we got to get to? What kind of offer do you need? She says, I cannot tell you. And that's the same answer I would get from 99.9% of realtors in the marketplace. Is that correct? Wait for it. I got to keep you engaged somehow. Okay. All right. I'm going to give you 5 more minutes. I'll give you a break. Broker authority. Broker will use reasonable efforts and act diligently to market the property. This is our responsibility for sale, procure a buyer, and negotiate the sale. It tells in the next box if we want it to be displayed on the internet or not. Paragraph C, we're authorized to market the property with the following financing options. Why wouldn't we automatically check every box? We don't care how they finance it, just bring us a good offer. Oh yeah. Rarely do they want to own or finance, but why would they exclude, for example, FHA or VA? Maybe we already know we got a bad roof. Okay. Conventional doesn't know. VA and FHA send out an inspector to look at it. And we know we're not going to mess with that. Okay. Or this is very common in this market right now. Because prices are rising so dramatically, we want the buyer to sign the appraisal addendum, giving up their right to cancel if the appraisal is less than the contract price. Can they do that with an FHA or a VA? No, prohibited by law. But conventional, can they do that? Yeah, so maybe they're saying, don't give us a government-backed loan. Take cash, give us conventional, but we're not even going to look at other offers. Okay, this is how you would indicate that right there. Okay, and you need to have this conversation with your sellers. And if you anticipate you're going to be in a situation where you think you're going to sell it over appraised value, then you probably want to nip that in the bud right here. Okay. All right. Paragraph D talks about what you can do to market the property, putting for sale signs out. There we go. Oh, here we go. Look at paragraph 8. In response to inquiries from prospective buyers and other brokers, disclose whether the seller is considering more than one offer. Broker will not disclose the terms of any competing offer. Wait a minute, unless specifically instructed by seller. Now let's pause and talk about this for a minute. Would it ever be in the seller's advantage for us to disclose terms of offers we've received? Let's say that I made that offer $365 cash on Sunday night, and the listing broker had one at $370 cash. That was the highest offer. If I was in her position, I would go to my seller and I would say, we got a $370, but somebody's come in hot at $365 and they've told us they want it bad. Would you authorize me to tell them we got a $370? You bet it's in their best interest. But lazy agents just say, I can't tell you, I can't tell you, I can't tell you. And they give up thousands and thousands of dollars that their seller could have received. How high would my buyers have gone? Probably 380. Probably 380, because daddy was buying the home for cash and he's got lots of it. So please, please, as a listing broker, don't automatically say, I can't tell. You have a fiduciary responsibility to your seller to act in their best interest. And that means get them the highest price for that home under terms acceptable to them. So be a smart agent, be a hardworking agent, and go the second mile for your client. And if that means, hey, I got a 370 cash, 21-day close, what you got? Can you beat that? Can you bring me a better offer? That's what you ought to do. Okay? Makes sense, doesn't it?
It's true. Yeah, it's frustrating because I pulled my mom's house like 6 months ago and my insurance had like 20 offers.
Yes.
I was told that I had several agents asking me that same thing.
Yes.
And I would ask Lisa, and she's like, no, we can't think. You're telling them.
Typical realtor. But now we're special realtor. Now we know. We've been enlightened because we did what? We read the contract. Okay. You have heard me say that's our unfair competitive advantage. If we read the contract, now we're going to get a better deal for our sellers. And as a buyer's agent, we might have to educate the listing agent and send them to this paragraph and say, you know what? Would you just please go back to your seller and ask for authorization? Because I might be able to get you a better deal. We're not just going to throw numbers out in the dark, but if you can give us a target, we might be able to beat it.
So, perfect. So I took a client on Friday to see acreage with a house, and we're asking $795. My client was probably looking at that, maybe a little less honestly, because it's actually the service.
Yep.
And he said, hey, we just got an offer this morning, just to let you know, we're coming out that afternoon.
Right.
But I have been smart to say, can you tell me what that offer was? Because wouldn't he just say, oh, it's full price cash, even if it wasn't, wouldn't he lie?
He's not. Okay. So one of the obligations, this is a legal obligation of every real estate agent to every party of the transaction to be honest. Nobody is permitted to lie, even if they think it's in the best interest of their client. That is one of our stated legal obligations, to be honest with all parties. Okay? Okay, let's scoot down to paragraph 12. Seller representations. And what this means is these are the things that the seller is saying are true. They're representing these things as true. Seller has fee simple title. You know what? It's straight up 11. Let me give you a 5-minute break, and then we'll come back and pick up in chapter 12. Okay? There's only 2 stalls. Y'all hurry.
So it's not a one. Nothing popped up. I didn't know if Mark had said it. I tried to do something and also another list. So I just long. That's like 42. Yeah, that's no, it is a fun one. Find something like it's fun. So
Is this a wall or wall?
No, I'm thinking one.
But it's not a CP in it. We must be signing it.
I think we do have an approved CE class. So let me ask Robin. to bring this in. Okie dokies, let's go ahead and keep rolling. I see a few empty seats. They'll fill in. Hey, by the way, if we go till 1 o'clock, I think I can get you 3 hours of CE credit. So we're going to bring in the forms and have you sign. Okay. All right. 3, 2, 1. Chapter 12, paragraph 12, seller's representations. Seller has fee simple title and peaceable possession to the property. Just sign these up. Robin will pass them around. And all its improvements and fixtures unless rented and legal capacity to convey the property. In other words, I own this land. I own this home and I have the right to sell it. Seller's not bound by a listing agreement with another broker. There's an important one. I don't have two exclusives. C, any pool or spa or any required enclosures, fences, and gates apply with all applicable laws and ordinances. In other words, I didn't just dig a hole and fill it with cement, put water in it, and call it a pool, because that would be a violation of something. If not zoning, or what do they call it when you get approvals to build something? A permit. It was not properly permitted. Thank you. No person or entity has a right to purchase, lease, or acquire the property by any option, right of refusal, or other agreement. Seller's current and not delinquent on all loans and financial obligations except, and they can list them there with the expectation that will be cleared up at or before closing. Seller's not aware of any liens or encumbrances except, same expectation. The property's not subject to any jurisdiction by any court. In other words, we're not in bankruptcy or anything like that, or in foreclosure. All information relating to the property seller provides to broker is true and correct to the best of seller's knowledge. The name of any employee, reload company, or other entity providing benefits is, and then finally, the seller listing content and the license granted to broker for the seller listing content do not violate or infringe upon the rights, including copyrights, of any other person or entity. So if the seller gives you photographs or the seller gives you video, they're affirming here that they're not violating anybody's copyright. You might want to check that out for yourself. It's a fairly unusual situation. 13, seller additional promises. They just promise to cooperate, to make the property available, complete disclosures, and etc. Pretty straightforward stuff. 14, excuse me? Keep it clean is very subjective. It does say cooperate with broker to facilitate the showing, marketing, and sale of the property, but it doesn't say pick up your dirty clothes, put away the roach spray, okay? Number 14, limitation of liability. If the property is or becomes vacant, seller must notify seller's casualty insurance company and request a vacancy clause to cover the property. I don't know if that ever happens, but you know rates for a vacant property are higher than insurance rates on an occupied property because it's more likely to be vandalized, arson, burned down, that kind of stuff. But anyways, they're promising to do that. Broker's not responsible or liable in any manner for injury to anybody, while showing the home or as a result of the marketing of the home. Also, it says we're not responsible for, wrapping the water pipes or curing any dangerous conditions. That's all the responsibility of the seller. Seller agrees to protect, defend, indemnify, hold broker harmless from any damage, costs, or attorney's fees caused by seller or arising by any failure on the part of the seller or the seller giving incorrect information. Okay. 15, special provisions. I don't know that I've ever put a special provision in a listing agreement. Anybody ever done one of those? Can you think of any circumstance that would be required? Yeah, it's very unusual. Sometimes we'll have them in a sale contract. I've never seen them in a listing agreement. Paragraph 16, default. What it says here, if the seller defaults, they're going to be liable for our commission. If broker breaches the listing, broker's in default and seller may exercise any remedy of law. That's pretty vague. Mediation 17 says if there's a dispute, we agree to mediation. 18, attorney's fees. It says that if we have to sue each other, whoever wins the lawsuit is entitled to getting their legal expenses back. By the way, that's not a given in the state of Texas. You know, if somebody sues you and it's some frivolous thing and it costs you $100 grand just to get before a judge who eventually dismisses it as frivolous, you have no right to go against the party who made you spend $100 grand. There's no automatic right of getting your legal expenses paid. I think that's almost criminal, you know, because it encourages frivolous lawsuit and encourages people who have a lot of money to prey upon people who don't, because they know that they can bankrupt them in legal fees, or just the threat of having to spend $100 grand to get before a judge will cause them to give in and yield their rights. So in some states and some countries, prevailing party is always entitled to their legal expenses. And I wish it was the same way here, but we have it in our contract. Because we've put it in the contract, it is available to us. Paragraph 19, this is where we indicate any other documents that are part of this listing agreement. And there's always going to be some, an HOA notice, a MUD notice, seller's disclosure, on and on and on. Okay, so we want to just check the ones, and this is what links them to the listing agreement. The agreement of the parties, that's just all boilerplate legalities. Additional notices, paragraph 21, broker's compensation is not fixed. So though we like to quote 6s and 3s, that's always completely negotiable. In accordance with fair housing laws and the code of ethics, broker services must be provided and the property must be shown and made available to all persons, regardless of protected class status. So if some seller tells you they want to discriminate against somebody, they don't like Lithuanians or whatever it is, you may not represent them. Now, there are some circumstances in which it is legal for people to discriminate. For example, they're in a duplex. They live in one side, they're going to rent out the other. And they don't want to rent to anybody with children. Are children normally a protected class? What's it called? Familial status. Familial status is a protected class. And normally a landlord is not permitted to discriminate against families with children. But in a duplex where the owner lives in one side and they're renting out the other, they are legally permitted to discriminate. But this is the important part. You, as a real estate professional, according to the laws of Texas and the code of ethics that we subscribe to, are not permitted to represent them. Even though it's legal for them to do it, it's not legal for us to participate in a discriminatory act, even if it's legal. Okay? And it's legal in very few circumstances. Okay, but we want to, if a seller communicates that to us, we want to immediately withdraw from the relationship. Broker authorizes us to put it, seller authorizes us to put it on the MLS. We advise the seller to remove or secure jewelry, prescription drugs, other valuables, firearms, and any other weapons. We have this on our checklist of working with sellers, but it's right here in the document. And this is a great place to have that conversation. Talks about lead-based paint disclosures, foreign persons, warning about wire fraud, et cetera, et cetera. So those are just general notices, and then we get all signatures. Ladies and gentlemen, that is the listing agreement. Any questions? Did we skip over anything that is of interest to you? Did we go too fast anywhere? Are you ready for the quiz tomorrow?
This last section, foreign person,
Yes,
someone's coming down here from Canada,
yes,
they hold back half,
yes.
that's considered a foreign person.
So yes, if they're not a US citizen, they are a foreign person. But let me just read this to you. If the seller, so we're really talking about our client in this situation, not a buyer from Canada. Because where this shows up is where the seller is a foreign person. There's no issues if the buyer is a foreign person, okay? If seller is a foreign person as defined by federal law, a buyer may be required to withhold certain amounts from sale proceeds and deliver the same to the IRS. This is talking about the FERPA laws, where if there is a tax liability generated by the sale of the home, and the seller skips the country and goes back to Kazakhstan, the IRS is going to go after the buyer to pay those taxes. And so what it's saying here is if the seller is a foreign person, you will want to escrow funds with the title company sufficient to cover any tax liability.
And the title company will know how to do that.
They do, yes,
Just put it in an escrow account.
they do. And it's not their responsibility to do so. It is technically the buyer's responsibility to make sure that happens because they're the ones who are going to be held liable. But the title company does this every day, and they will cooperate and will often take the lead in determining the foreign status of the seller and doing escrows if necessary.
But being that this is a listing agreement, and buyer's agent don't get to see this.
Yes.
The listing agent lists it on the MLS, is there a spot?
No, but in the 1-to-4 family contract, they can disclose if the seller is a foreign person, and the title company is absolutely going to send them an affidavit as soon as they receive the contract, where they affirm that they are or are not a foreign person.
So the buyer's agent has to ask.
Buyer's agent should ask. It is not, I'm saying two things, they may sound contradictory, they're not. I'm saying the title company will take the lead in figuring this out, but it's not their responsibility to do it. They're under no legal obligation to do it. It's the buyer's responsibility. But the title company does it every single day, and they do it routinely. Okay? Yeah, in filling out the listing agreement, we're going to cover this paragraph, and they are going to disclose whether they are or are not a foreign person. Okay? They may not know. Yes. Sure.
As far as broker compensation, will there ever be a time where the buyer will pay all the fees?
Yes. Yeah, the question is there ever a situation where the buyer pays all the fees? Absolutely. A buyer representation agreement outlines the compensation to be paid to the buyer's representative. And it states in there, the listing broker will typically pay the compensation. But it says, if listing broker does not, buyer agrees to pay the commission or to make up any shortfall in the agreed upon commission. So the buyer rep agreement may say, I'm going to be paid 3%. The listing broker may be offering 2%. If that's the case, your buyer's going to be on the hook for the 1. Okay? And you are seeing that happen increasingly right now. What we used to say is you may have to give a little on the commission on the list side because you're often in competition, but as a buyer's rep, you're going to get 3% pretty consistently. I can't say that now. The last one I sold was 2.5% to the buyer's rep. Okay. That's right. Yes, that's right. The big iBuyers are offering less. And many agents now are taking 5% listings, 4% listings, and sometimes they will, let's say they take a 5% listing. Sometimes, this is the way we always said you should do it, pay yourself 2 and offer 3. Always offer 3 because that incentivizes agents to bring their buyers to show the property. But what I'm seeing now in this market, if they take a 5% listing, they're doing 2.5, 2.5. And I heard about one case recently, one of our agents was involved in. Listing broker got paid 3, buyer agent 2. That's a sign of the times in a seller's market where they feel like, I don't have to incentivize a buyer broker. Shortage of inventory, they're going to be submitting offers no matter what. So just kind of a sign of the times. Okay, there's some different directions we can go. We're halfway through our class. Are there any other listing documents that you want to make sure we cover? Because we can't get to all of them. Okay, let's go back here and look at the list, because we can take a look at any one of these that are of particular interest to you. Let's see, did I scroll past the paragraph where we list the related documents? I think I did. You want to look at the mud? All right, let's just go ahead and do that. Let's get down in the mud. So it's in paragraph 19. Let's look at that real quick. We'll get to the mud. IABS, seller's disclosure notice, lead-based paint, T47, minerals, on-site sewer, condominium addendum. Okay, any of those stand out as things you're really interested in? Okay, we'll go to the mud, and then I want to talk about seller's disclosure. Okay, and then we can hop on any of these others, lead-based paint or other addendums. Okay, let me get out of this. There we go. So I'm staying in HAR. MUD stands for what? I think it is water. We call it the MUD, but it's called the water district. That's important when you're trying to find documents, right? To know the keyword. And look at the title of this one. It doesn't say MUD or municipal. It says notice to purchaser of real property in a water district. Isn't that interesting? Here we go. So we'll talk about this, and then we'll talk about how you find out if it's in a MUD and the importance of getting this disclosure made by the seller prior to entering into a contract. Okay. Any specific questions before we get into it, Jorge? Is there something already you know that you need clarified? Okay.
I know that we go to practice and we find one.
Yes.
So there's always one listed on,
Yes.
but most properties have no one.
Okay.
Find the same.
Okay. All right. Great question. So he's like, Jorge is saying most properties are in more than one MUD, and one of them is typically listed under taxes. How do you find the others? Okay. So I'm going to challenge a little bit of that. Most properties are in a MUD, but there's only one. Now, there are situations where there are 2 or 3 MUDs, and I'll show you how to find that. You're actually on track with your answer. Okay, let's get into this. This is a disclosure from whom to whom? From the seller to the buyer. And what are they disclosing? What are they telling the buyer with this document? What story are they telling? That's right. There is an entity, a water district, that has taxing authority over this property. And I'm going to disclose to you, Mr. and Mrs. Buyer, how much tax is being levied, the tax rate against the property right now. I'm also going to disclose to you if there is additional bonds, additional indebtedness to be incurred by this district in the future that could potentially raise the tax rate. So I'm going to tell you what is and what might be. Okay, that's the story the seller is telling to the buyer. So let's get into the let's look at the box first. Note, This notice should be completed and given to a prospective buyer prior to execution of a binding contract of sale and purchase. Should be executed by the seller and purchaser and should be attached as a separate portion of a purchase contract. Please see note at bottom of page. Okay, let's go to the bottom of the page. Note, correct district name, tax rate, bond amount, legal description are to be placed in the appropriate space. Except for notices included as an addendum or paragraph of a purchase contract, the notice shall be executed by seller and purchaser as indicated, and so on and so on and so forth. There's a blank at the bottom of that paragraph that where you insert the year that this tax rate and indebtedness applies to. Many agents fill in the current year, 2022, and that is never right, okay? So you're gonna look and see what, and I'll show you where to find the proper year. Okay, it's easier than you think, okay? All right, paragraph 1. The real property described below that you're about to purchase is located in the blank district. And here you're gonna write in MUD 249 or whatever it is, whatever the name of that district is. The district has taxing authority separate from any other taxing authority and may, subject to voter approval, issue an unlimited amount of bonds and levy an unlimited rate of tax in payment of such bonds. Well, that's kind of reassuring. As of this date, the rate of taxes levied by the district on real property located in the district is blank on each $100 of assessed value. So that's going to be a rate. If the district has not yet levied taxes, the most recent projected tax rate as of this date is so many dollars on $100 of assessed valuation. The total amount of bonds, excluding refunding bonds and any bonds of any portion of bonds issued that may be payable solely from revenues received or expected to be received under a contract with a governmental entity approved by voters, blah, 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 is blank. And then the aggregate of initial principal of bonds issued is blank. So those two last blanks say, this much has been authorized, $22 billion. This much has actually been spent, $8 billion. So when you're putting the numbers in, remember this, big, little. Because you're gonna see two numbers, bonds authorized, bonds issued. Bonds authorized will always be equal to or larger than bonds issued. You can't issue more bonds that have been authorized. So remember, big number, little number, okay? And we'll show you how to find those numbers. Okay, paragraph 2. The district has the authority to adopt and issue a standby fee on properties. Has anybody come across a standby fee recently? I have not. I don't think I've ever seen a water district notice with that filled in. So I'm not going to spend much time on it now. In fact, we're done. Paragraph 3. Mark an X on any of the following 3 spaces and then complete as instructed. So what you're going to do now, or what the seller is doing, is revealing where this district is located. Is it within the boundaries of another city or municipality? Is it outside the boundaries of another city, but that city has the authority to incorporate it? Or is it way out in the country and it's truly independent, not within the boundaries of anything else and not subject to what's called the ETJ, or the extraterritorial jurisdiction of a municipality? You see, just because you're outside the city limits of Conroe doesn't mean Conroe can't reach out its tentacles and scoop you in, or the city of Houston. In Texas, municipalities have that authority for a geographic area around their city or municipality limits. Okay, it's kind of weird, isn't it? ETJ. So here's what we're disclosing. Notice for districts located in whole or in part within the corporate boundaries of a municipality. We are in the city limits of Houston. We are in the city limits of Tomball. That's what that means. We're within the city limits. Notice for districts located in whole or part in the extraterritorial jurisdiction of one or more home rule municipalities. So we're not in the city limits, but they can get us anytime they want us. Okay, we're in their ETJ. And then notice for districts that are not within the city limits or within an ETJ. So the seller has to disclose that, okay? Now, they have to provide additional information. If the answer was A, we're within the city limits, they have to write down the name of the city. If it's B, they're in an ETJ, they have to write down the ETJ of the city they're within the boundaries of, okay? Then all parties sign it and they're required, the seller's required to provide this when?
You should have it signed before the contract.
That's right. Yeah, typically it's going to be signed along with the purchase contract, but you want to provide it prior to that time so they have time to review it. And that's what it's. Yes, so let's just talk about that since you brought it up. If this notice is not provided to the buyer prior to or at execution of the sale contracts, the buyer has an automatic right of cancellation of the contract and the right to receive back their earnest money deposit right up until the day of closing. Okay? And most listing agents are unaware of that. And you know that because quite frequently they don't provide this as an additional document on the MLS. And quite often they'll say, oh, we'll get around to it. Let's get an agreed upon offer. Let's get signed off on the offer, and then I'll get that other stuff, you know, buttoned up and sent over to you. And you, as a buyer's agent, you say, that'd be fantastic. Thank you. Because you know, you got your back pocket, you got to get out a free card for your buyers. Now, high level, Ryan Barker called me a couple of weeks ago to run this scenario by me. He says, we're in a competitive buyer situation. I'd like to submit an offer without an option period. Would that be attractive to a seller? Highly attractive, no option period. He said, because they have not provided a MUD notice. And he said, this would essentially be our option period without having to pay for it, and one that it would extend not just 7 days or 10 days, but all the way to closing date. He said, is that legit? And I said, absolutely. If it's in a MUD and they've not provided the notice, you essentially have an option period all the way to closing. Okay, so just think about that. That's your unfair competitive advantage. Okay, yes. Yeah, so it's technically the seller's responsibility to complete this notice. But we know they have no clue how to complete this notice. So it's typically the listing agent who completes it, explains it, and has the seller sign it. The listing agent then puts it up on the MLS under additional documents. And the buyer's agent, when preparing to submit an offer, downloads all of those documents, seller's disclosure, HOA, MUD, survey, anything else, T47, and presents them to the buyer for review. Okay? Now, the question was, where do you find this information? And the simplest way is on the MLS. Let's see here if I can navigate while we're still broadcasting. Let's go backwards. So I'm going to go into Matrix, logged in as a realtor, and go to, let's find a property first. Who has a property, who knows an address?
6129 Elton.
6129.
Elton Knowles.
Okay, there we go. Let's take a look. Oh, look at all those documents uploaded. Is this your listing? Oh, that's right. This is the one we're talking about. Okay. So 6129 Elton Knowles. I'm sorry, I didn't want to even go to the address. let's open the MLS number. There we go. So,
And I love that, hey, y'all, this is coming up.
yeah,
Maybe it's cool.
nice listing. It doubled double the price right now. So what I did, I just clicked on the tax tab, and what it's doing is providing some basic information about the property, assessed values, legal description. What I'm looking for here is the entities. Look under jurisdiction. These are the entities that the property is liable for taxes on. Cy-Fair ISD, Harris County, HC Flood Control District, Port of Houston Authority, Hospital District, Education, College System, MUD 105, and Emergency Services District 9. Where's the MUD on that? MUD 105. How many MUD notices do we need on this home?
So that was my question, is about one of these forms for every single.
Correct. If it's subject to more than one water district, you're going to have a separate notice for each one, because each one's going to have a different tax rate, right? Different bond, different indebtedness. So separate ones. Okay. So I'm going to keep this open if I can. Actually, somebody just remember this for me. You ready? HC. What would that stand for? Flood Control District. Y'all see that on there? You notice the notice doesn't say MUD notice. We talked about that earlier. It says what? Water District notice. Okay, so just hold on to that. Hold on to that. So now I'm going to go backwards in here in the MLS. I'm going to come up here to public records. See where it says MUD bond information right there? Wasn't that MUD 109? 105? So what I like to do when I get here is just do a Control F and type in 105. Oh, look at all those. That's a whole. Oh, there's only 13. So let's do our MUD first. Let's get down to MUD 105. So I'm just searching through all the 105s. There's only 13 of them, so I'm going to get there. There it is. HC County MUD 105. And you'll see the tax rate is 0.77. We put that in that first paragraph. What is the tax year? Where do we put that? Very bottom, that notice paragraph at the bottom. We don't put 2022. You might think, okay, we'll put 2021. No, tax year 2020. That's the numbers these apply to. And remember I said there's a big and a little. You put the big first and the little second. So bonds authorized in this case is 124,500,000, and then issued 79,375,000. So they're only about a little more than halfway through their money. Okay. So there we fill that out. So we fill that out, we submit it, we get the seller to sign it, we provide it, we think we've done our job, right? But we did see that thing that set off alarm bells. HC water something. Is that what it said?
Yes.
So let's do the same thing. Let's do a control find, and it said flood, that was the name? Flood control. Let's just search the word flood. How many times does that show up? Oh my goodness gracious. Look at that. HC Flood Control District. You know what that means? We need 2 MUDs. That's right. I did a Control F search on a keyword and my word was flood. And sure enough, that entity this property is paying taxes to shows up on the MUD notice list. And there's the details. There it is, identified exactly by name. So now if I, as the listing agent, provide the MUD 105 notice, but I don't provide the Harris County Flood District notice, I have given that buyer a get out of jail free card. Yes.
This is
this that we're putting up here, this is particular to this
Yes,
particular
this particular property. Yes, yes. But I suspect most, if not all, of the properties in Harris County are going to be subject to the Harris County Flood Control District. So when you see that listed as a taxing entity on the tax roll for that property, you need to come and look. Oh, and if it's listed as a taxing entity, then it's applicable.
So
Okay.
I'll need two of them.
You'll need
So
two.
will the keyword be flood? Will that help us out? Like when we're looking
So
at-
you want to look at how is the taxing entity described on the tax roll? And in this case, I said, write it down or remember this, and it was HC Flood Control District. And I'm thinking HC, there's probably a lot of those. It stands for Harris. There's probably a lot of Harrises. District, there's a lot of those. What's the most unique word that I could search on to help me find it quickly? And flood turned out to be a good one because there were only two. Sometimes you got to play around with it a little bit though, okay?
This is underneath.
So yes, so what I did is kind of, no. I like to learn something every day, but no, I did not just learn this now. So, okay. No, it's all gay. You can ask me anything. So what we did, let me go back here. Will was saying, where did you find all this? In Matrix. Look right here, public records. Realist tax, matrix tax, mud bond information. So we could have just gone into matrix tax and put in the address here. We actually pulled up that listing because she gave us an address. But if it wasn't an active listing or we couldn't find a listing for it, you could just come in here and search any property. And by owner name or by address, and it'll pull up all the taxing entities that have jurisdiction over that property.
So will it pull up both muds on this if you put in the address?
Well, it did. Remember, we saw it.
I didn't remember looking at this screen.
Well, we went at it in a different direction. So what was the house number?
6129.
6129. And the street name?
Elton, no, K-N-O-L-L.
Okay, see, there it is. Let's look it up by parcel ID. Okay, here's all the tax information. Here's all the taxing jurisdictions that we looked at. There's MUD 105 and there's HC Flood Control District. Right there. Okay.
If you went through HCAD and checked the address, would you get the same information? Just to get some information, but maybe. Yeah.
So the question is, would we get the same information under HCAD? 6129.
You got Elton, no. Oh, see, you put the temp here at 22.
No, I didn't put that in.
Oh, I mean, does it automatically just go?
So here we go. There it is. This is under HCAD, and there it shows it, flood control and MUD 105. So it's there.
I wouldn't have known necessarily to go to Harris County Flood in addition to what.
Aren't you glad you came to class? Yes, first of all, you look at this list of the taxing entities and you say, does any of those look like it might be a water district? Well, the MUD is a given. But flood has to do with water, doesn't it? Okay, now there's another one there we might want to investigate. Port of Houston, right?
Somebody just, my client asked me that yesterday, and I was like, oh, let me get back to you. I was kind of embarrassed. I didn't do that.
So let's check, right? Because we're going to be diligent agents, public records, MUD bond, and we're going to do Control F, keyword search, port. How many of them? There's 10. Newport MUD shows up. Oh, because Newport. Port of Houston Authority.
There's another one.
Ding, 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 ding. You win a prize. We thought we were covered with 2 muds. Now we got 3. We got to fill out 3 muds on this property.
Good thing we went page.
Oh, and no, it shows, Port of Houston shows on all the others.
It does.
We just,
I was trying to-
that was hilarious. You have to do some stand-up. Yes, Bob?
You were gonna tell us where to find the year on the bottom of mud notice.
So it's right here. So like on Port of Houston Authority, Harris County, there's the rate, there's the year, 2020.
The year you put on.
Yes,
On that.
that's right, because that is the year to which these numbers apply. Okay? Yes.
I see that the numbers are the same, so do you still need to fill it out because it doesn't, is it my looking at the right line?
Yeah, 917, 917.
Right, so do you still need to fill it out even though they're matched and there won't be any extra tax or anything?
No, but this is being taxed right now. Because what it says is we've been authorized to issue 917 million in bonds, and we've issued 917. But you know what we're doing now with those bonds? We're paying them back. A bond is an indebtedness. How are we paying them back? That property is subject to a 0.01 per dollar of valuation. That's 1%. So we're all these bonds, we're not issuing more, but we still got to pay for the ones we got with that 1% tax or one. Yeah, it's 1 cent per $1 evaluation. Or is it $100 valuation? It's 100. So it's 1/10 of 1% we're paying in tax rate. Yes?
That goes in those 2 blanks on section 1.
Correct. The last 2 blanks, I said put big and little. In this case, they're the same. So you just put 917 and 917. Yeah, that goes in the tax rate where it says, what is the rate of tax? 0.01 per $100 to pay for that big, pretty port. Yes,
So on this property, I would be doing 3 of them.
that's correct.
Okay, so we just put the different, not everything else, just whatever.
You just follow the blanks, whatever they are for each one.
So those are the 3 words we need to look for: water, mud,
Yeah,
flood, and force.
yeah.
Any other words, Frank?
Well, perhaps. I mean, what you want to do is you want to look over the list of taxing jurisdictions and just say, does anything here have anything to do with water? I mean, it might say sewer. That would be a flag, you know? Just, yeah, big number, little number. Okay, guys, wow. That mud took almost as long as the listing agreement. So, yes, Letty? Yes. So, yeah, I'm in, yeah, HAR right now. I am there. So let me close out. You like HCAD? Yeah. So public records, Letty, realist tax, it gives you options: realist tax, matrix tax, and mud bond info. Okay. All right, guys, let me give you another 5-minute break. This will be our last break. Make the most of it, and then we'll reconvene for the final stretch. I want us to look at the seller's disclosure. Okay. All right.
So you know how I normally put mud, probably answer this question, but I know that you do. So the next one I just put Port Authority, whatever, and then the other one, flood.
That's right. When it says what the name of the district is, you're going to put Port of Houston or whatever. Mud 105, Harris County Flood District. Yeah. Okay. 5 minutes. No refill. Yeah, so You can. It will automatically lock behind you. No, no alarm. So Dario, I pulled up the residential lot information form in forms. Oh, that's right. That's, yeah, it's not listed.
Yeah. 'Cause I'm pretty sure there's one on the car that's solved. Residential. Use under lot.
Okay. Let's see here. What was, oh,
Do those fall in a question on when you should have to sign the same day of the contract a month? Would that apply to the other ones that also bring?
so no, well, those are all months.
Okay, so.
And all of them must be presented to the buyer prior to execution of the contract.
Right. But it, so it does fit under there, is there saying?
Yes. Yeah, yeah. It feels like you dodged a bullet, doesn't it? Yes. That's because most people don't know. Most agents don't know.
Found this one, but I don't know.
Exclusive real estate right to sell.
This is
Land improvement. That looks like that's the standard listing agreement.
yeah. I mean, like I said, it looks the same.
How do I list a lot in Texas? Listing agreements.
Because there's obviously this one, but I just can't. I haven't compared them yet. So.
Yeah. Okay. Okay. Well, let's just keep.
I just want. I guess this one's the date on this one. Oh, this one is just an older one, so it is like the 1101.
Yeah.
And it looks like just the one on here on special updated.
Okay, here we go. This is HAR. Either residential, commercial, or farm and ranch, depending on the type of property. If you're listing a residential lot, you would use the same listing agreement as you would to list the home.
Yeah. The more you know.
We got the answer. All right, y'all ready? You ready for the final stretch? I'm not going to keep you 3 hours today. You've been saved. We're going to look at the seller's disclosure notice and then wrap it up. Yes, sir. Yes, we do. So at 1 o'clock today, so you'll have time for lunch. I'm going to let you go in about 5-6 minutes. But Kevin Miney and Ryan Barker are going to teach 1 year 6 figures, which is a 3-hour CE credit. It's free business planning class. It's going to teach you about all the options for growing a business. And then by the end of it, you'll have a personalized business plan that you walk out with. Okay. And you'll see that it mirrors so closely what we're doing on the Frank Gray team, because our 4 core sources mirror the 1 year 6 figures, previously the Aspire business plan. Okay. So it'd be good. If you've not attended it, I do recommend it, and you will get 3 hours of CE credits. So yes, Bob?
Real quick, back to water district notices. In the termination of the contract, notice of buyer termination, there's no option for the water district.
Yes.
Issue.
Yes.
And the only option is number 8, which is identify the paragraph number of the contract or the addendum, but it's not an addendum either.
It's a notice, right?
It's a notice, but I guess that's the only place you could check.
Yeah, you could do that.
And legally it works because it's not an addendum and it's not in the contract.
Yeah, so there is a right of cancellation, even though all it says in the notice itself is that it must be presented prior to execution of a contract. It doesn't specify the consequences, but in the Texas Water Code, it spells out the consequences, which is that buyer has the right to terminate the contract and get the earnest money back right up to the time of closing. So
what would be the verbiage we would put in here?
Failure of seller to provide water district notice prior to execution of contract. You're welcome. Okie dokie. So let's look at one last form, and that is the seller's disclosure notice. And let's see here. Sellers, I should just put disclosure. Let's make it simple. Seller's disclosure notice, TAR. That's what I'm going to look at. Yep, here we go. So there are 2 seller's disclosure notices that are available to you to provide to your seller. One is provided by TREC, the other by TAR, T-A-R. Most agents are taught to use the TAR disclosure, the one on the screen. And if you've been hanging around with me for any length of time, you know that is the wrong choice. And I say that on the advice of TREC attorneys, because I'm authorized to teach TREC Legal Update 1 and Legal Update 2. And to gain that authorization, I have to attend a class with TREC attorneys every 2 years. And do you know what their hot button topic is every time? seller's disclosure notice. The TAR disclosure notice goes well beyond the requirements of the Texas Property Code. It requires sellers to disclose things that are not required by law. And by doing so, they actually create additional liability for the seller. If you're the listing agent, the seller's your client. How dare you give them a form that creates more liability for them? Now, the reason that this is a little known fact is that most Trek instructors don't pay attention when they go to the certification class, or they would be getting this word out, and they're not. The 3 Ds of real estate, what are they? That's right, disclose, disclose, disclose. The TAR disclosure asks the seller to disclose more. So we intuitively think what? That's a good thing. It's safer, they're disclosing more. But in this case, our intuition has led us astray. Okay? Let me just give you one. There are several examples on this form. I'm just going to give you one because it is the one that gets most sellers in trouble. Oh, here, let me do my quick search. F, inspection. Okay, oh my goodness, there they are. Okay, we are in section 10 on page 5. Okay, let me get rid of this. Section 10, page 5. Listen to this question. Within the last 4 years, have you, the seller, received any written inspection reports from persons who regularly provide inspections or who are otherwise licensed as inspectors or otherwise permitted by law to perform inspections? Yes or no? This question is not required by the Texas Property Code. This is an additional disclosure. Now watch what happens. If they say yes, if yes, attach copies and complete the following. Inspection date, type, name of inspector, number of pages. You know the problem with that? Well, many sellers cannot comply with that. What if a buyer had an inspection 2 weeks ago on this property? They didn't like what they saw. They busted out. They never provided a copy of the inspection to the seller. How must the seller answer this question, yes or no? Yes, an inspection was done. Can I now provide a copy of the report? I am in default of my own disclosure right now. Now think about it. And that was 2 weeks ago we had this inspection. What about the last 4 years? Have you had your HVAC inspected? Maybe you're having a little trouble. Maybe you wanted to have it winterized. Maybe they provided you with a report. Do you still have a copy of that report? You are in default of your own disclosure. And that default creates room for lawsuits. What the Trek attorneys say, and who provides our license? Trek. That's who I'm listening to as my authority. The people who have control over my livelihood. They say the Trek seller's disclosure mirrors the requirements of the Texas Property Code, the legal disclosures required by a seller. And to go beyond that creates really tough situations like this. And there's more on here on the TAR that creates more risk and liability for the seller. And Trek says, don't do it. Since they are the ones that issue our license, I'm listening to them. So I'm using, and I encourage my sellers to use, the Trek seller's disclosure. And we've had buyer's agents say to our listing agents, you provided a Trek seller's disclosure, our buyers want the TAR. Can you believe that? Yeah, they actually, we've heard that recently. Yes. Yeah, okay. Well, don't trust me, it exists. If it's not on HAR, you can get it on zipform.loop, transaction desk. or through the Trek website itself. Okay? Now, when that happens, what I counseled our agent to say is the Texas Property Code is the legal body of law that governs seller disclosure, and the Trek seller's disclosure mirrors the Texas Property Code. That is the only disclosure that we're going to be providing. Okay? Okay. All right. That's what I wanted to share with you. Any questions? Okay. Appreciate y'all being here, hanging in with me. Tomorrow at 9 o'clock, you are invited to log into my coaching call. It's going to be on www.gotomeet.me/Abbey Realty only. Will not be live in class, only online. I'm going to share 10 or 15 minutes of something that I'm passionate about. Might come from the Bible, might not. Just warning you. That offends you, you might not want to log in. And then about 9:15, we'll do 30 to 45 minutes of open Q&A. Ask any question you want about anything related to contracts, business building, or real estate, okay? And then at 10 o'clock in this room, we'll be doing contract mastery quiz. 50 questions designed to expose any lack of knowledge on your part of contracts. And it's going to be fun. I'm going to give you about 30 minutes to answer 50 questions, and then we're going to go over the answers, okay? All right. Get here on time. Don't be late for that. All right, guys. Appreciate y'all being here. Yes.